Listen very carefully, because what just happened inside a federal courthouse in Manhattan is not just another headline. This is one of those moments that will be replayed, analyzed, and argued about for years. A moment that doesn't simply add to Donald Trump's legal troubles, it detonates something far deeper, something far more dangerous. Something that reaches back into one of the darkest scandals in modern American history and pulls it, forcefully, into the present day. Late this afternoon, while Trump was sitting just a few miles away in another courtroom fighting for his political survival, a federal judge dropped a ruling that hit like a thunderclap, not in his criminal trial, not in the election case, but in a long-dormant civil lawsuit tied to the Jeffrey Epstein network, a case most people assumed had faded into legal obscurity. Instead, that case just came roaring back to life in the most devastating way imaginable for Trump. A federal judge has ordered the unsealing of secret testimony that has been locked away for over a decade. Testimony that directly references Trump's Mar-a-Lago estate. Testimony from a key Epstein accuser. Testimony that, until today, Trump's legal team had fought relentlessly to keep buried. And now, in just 48 hours, that wall of secrecy will crumble in full public view. This is not a leak, not gossip, not conspiracy, not something whispered in a book or floating around on social media. This is a court-ordered release. A federal judge has ruled that the public has a right to see what has been hidden for years. And that decision is sending shockwaves through Washington, through Florida, and straight into the heart of Trump's political machine. The ruling comes from Judge Jed Rakoff, a highly respected federal jurist known for his intellectual rigor and independence. This is not some partisan activist judge. This is a man with a long history of demanding transparency, accountability, and legal integrity. And in his order, he made something brutally clear. Whatever justification once existed for secrecy in this case no longer holds. The documents being released come from a 2015 defamation lawsuit connected to the Epstein network. At the center of this is a Jane Doe witness identified in court records as JPJ12. She was a teenager at the time. In her sworn deposition, she described being recruited by Ghislaine Maxwell while working at the Mar-a-Lago spa in the early 2000s. She detailed how she was approached, what was said to her, and the environment inside Trump's own resort. For years, Trump's legal team fought to keep that testimony sealed. They argued it was irrelevant, prejudicial, and damaging, but Judge Rakoff disagreed, emphatically. He ruled that the public interest in transparency now outweighs any remaining privacy concerns. In other words, the era of hiding behind legal technicalities is over. And let's pause right here because what this means cannot be overstated. For the first time, sworn testimony describing alleged criminal recruitment at Trump's Mar-a-Lago will officially enter the public record. Not as rumor, not as allegation, but as court-sanctioned evidence open to public scrutiny. This is a nightmare scenario for Trump. At the very moment this ruling came down, Trump was sitting in a Manhattan courtroom for his hush money trial. Sources inside the room say his demeanor changed instantly when his attorney leaned over and whispered the news. The defiant swagger faded. The familiar smirk disappeared. In its place was a tense, focused silence. Trump understood immediately what this meant. This ruling doesn't just revive the Epstein narrative, it weaponizes it. It moves it from the fringes of political attack ads and internet speculation into the center of Trump's legal and political battlefield. And unlike so many controversies before, this is not something he can simply tweet away, insult away, or bully away. Judge Rakoff's order reads like a legal hammer. He wrote that the passage of time, Epstein's death, and the conclusion of related criminal proceedings have fundamentally changed the balance between secrecy and transparency. He stated that the witness's testimony could shed critical light on the operations, methods of the Epstein enterprise, and that the public has a paramount right to evaluate that information. In plain terms, the court is now treating Mar-a-Lago not just as Trump's luxury club, but as a potential site of evidentiary significance in a sex trafficking conspiracy. That is a devastating shift in how this property will be perceived in the eyes of the law and the public. The legal implications for Trump are severe. Across multiple cases, his lawyers have consistently tried to block any mention of Epstein or Ghislaine Maxwell, arguing it would unfairly prejudice juries against him. This ruling undercuts that strategy at its core. Prosecutors in other cases, including the classified documents case in Florida, could now reference this publicly available testimony to establish patterns, raise credibility questions, or challenge Trump's narrative. A door has been kicked open. And once it's open, there is no closing it. Historically, this moment has eerie parallels to the unsealing of the Clinton-Lewinsky grand jury materials. In both cases, the courts ultimately decided that when scandals involve figures of enduring public importance, secrecy has an expiration date. Judge Rakoff is essentially saying, the American people deserve to know what happened inside spaces owned by a presidential candidate. That is a profound statement, and a dangerous one for Trump. The witness at the center of this, JPJ12, is now an adult. For years, her attorneys have fought to bring her story into the light, arguing that secrecy only protects powerful men while silencing victims. In her deposition, she described being approached by Maxwell while working as a locker room attendant at the Mar-a-Lago spa. She recalled conversations about travel, opportunities, and working for wealthy men, conversations that later, according to her, escalated into abuse. Her memories were not vague. She described the layout of the club, the staff present, and the environment in striking detail. That level of specificity could provide investigators with a verifiable blueprint, something far more powerful than mere accusation. And the timing? For Trump, it couldn't be worse. He is already sitting in a criminal trial, facing a jury that is judging his character every single day. Now, during recesses and breaks, news coverage will be dominated by the unsealing of Epstein-related testimony tied directly to his home. The hush money case in New York and the trafficking allegations connected to Mar-a-Lago will collide in the media, creating a relentless narrative of escalating legal peril. Politically, the damage could be just as catastrophic as the legal fallout. The ruling also orders the release of certain email communications between defense attorneys in the 2015 case. Legal analysts believe these emails may reveal internal discussions about how to handle references to Mar-a-Lago, potentially showing efforts to minimize, spin, or obscure the estate's role. If those emails suggest deliberate attempts to hide uncomfortable truths, it could raise serious questions about consciousness of guilt and who else may have been involved in those decisions. Meanwhile, the international community is watching closely. The Epstein scandal has always had global implications involving powerful figures, foreign governments, and intelligence agencies. The unsealing of documents tied to a former U.S. president's property will be scrutinized in capitals from London to Riyadh. Allies are bracing for political turbulence in an already volatile election year. Financially, this ruling threatens to strike at the core of Trump's brand. Mar-a-Lago is not just a residence, it is the centerpiece of his post-presidential empire, a social hub, a political power center, a symbol of wealth and influence. Now, in court documents, that same property could be associated with sex trafficking recruitment. That is a reputational blow that money alone cannot fix. The judge gave defense attorneys just 2 days to propose minimal redactions, things like phone numbers or addresses, but made it clear they cannot redact the core substance of the Mar-a-Lago testimony. That leaves Trump's current legal team scrambling. They now have to prepare both a legal defense and a public relations strategy before the documents even see the light of day, all while Trump is tied up in another trial. Security agencies are already on high alert. Officials expect intense reactions from both Trump's most extreme supporters and activists demanding justice for Epstein's victims. Mar-a-Lago and the federal courthouse are expected to see heightened security. Online, the potential for violent rhetoric is soaring, and law enforcement is preparing for multiple contingencies. Inside the Republican Party, this ruling has sparked a crisis. Do party leaders double down and defend Trump, tying their political future even more tightly to a scandal now validated by a federal judge? Or do they begin quietly distancing themselves, speaking carefully about respecting the judicial process while avoiding direct commentary? How they navigate this moment could shape the GOP's identity for years to come. Democrats face their own challenge. They will want to emphasize the significance of this ruling but must be careful, not to appear as if they are exploiting a sex trafficking case for political gain. Expect their messaging to focus on transparency, accountability, and letting the court documents speak for themselves. The White House will likely stay silent, but Congress may feel renewed pressure to investigate laws around club safety, human trafficking, and private resorts. This ruling could spark broader legislative action beyond Trump himself.
Which way do you think is best?
For the media, this is nothing short of a gold mine. Newsrooms have been preparing for months for the possibility of these documents being released. When the unsealing happens, reporters will comb through every page, every line, every name mentioned. The next 48 hours will become a countdown to one of the most intense news cycles in recent memory. Judge Rakoff's reputation makes this ruling even harder for Trump to attack. As a Bill Clinton appointee known for fairness and independence, he is not easily painted as a partisan enemy. His decision is grounded in legal principles of transparency, making it difficult to dismiss as a political witch hunt. Trump's legal team has already filed an emergency appeal to the Second Circuit Court of Appeals. But legal experts believe that appeal is unlikely to succeed. Overturning a judge's discretion-based ruling on public interest versus privacy is an extremely high bar. In reality, this appeal is more about projecting defiance than expecting victory. According to reports, the witness testimony also describes social events at Mar-a-Lago where Epstein was present. This aligns with photographs and guest lists that have circulated for years, but now adds a far darker layer. The testimony suggests these visits were not just social gatherings, but potential opportunities to identify and groom victims. If true, that transforms Mar-a-Lago from a passive venue into something far more sinister. This ruling is already reigniting calls for a renewed federal investigation into Epstein's network, particularly in Florida. While the Department of Justice has said its investigation is closed, the political pressure generated by these documents could make that position increasingly difficult to maintain. Florida state authorities may also feel compelled to revisit old evidence with fresh eyes. The ripple effects extend beyond Trump himself. His co-defendants in other cases, such as Walt Nauta and Carlos de Oliveira in the classified documents case, could now face tough questions about what they knew about Mar-a-Lago beyond just the storage of boxes. Prosecutors may use this to probe whether they ignored troubling activity or helped maintain a culture where rules were routinely bent or broken. Psychologically, this ruling is a body blow to Trump. He has built his entire persona around control of narratives, control of media, control of outcomes. This decision represents a dramatic loss of control. It injects a dark, persistent storyline into the final stretch of his campaign, one that is uniquely difficult for him to combat with his usual tactics of mockery and counterattack. And perhaps most importantly, this ruling could embolden other victims or witnesses to come forward. When one person sees their story validated by a court, others may find the courage to speak. That could lead to a cascade of new allegations, each one keeping this story alive and expanding its scope. In diplomatic circles, ambassadors from countries whose citizens were impacted by Epstein are already drafting formal inquiries to the U.S. State Department. They want to know whether this new information changes the government's stance on the case. These questions are deeply uncomfortable for the administration, forcing it to navigate between acknowledging troubling revelations and maintaining that justice was served. Judge Rakoff also made a pointed reference to the importance of historical accuracy in his ruling. That phrase is not accidental. It frames this decision as part of a broader effort to preserve a truthful historical record, suggesting that those who fought for secrecy were, in effect, trying to distort history itself. For the jury in Trump's ongoing New York trial, this news will be nearly impossible to avoid. Even with strict instructions not to follow media coverage, the sheer scale of this story will test their isolation. Trump's legal team could even file motions related to jury contamination if the coverage becomes overwhelming. On far-right media, Trump's allies are already trying to spin this ruling as a conspiracy, portraying Judge Rakoff as a puppet of George Soros and the witness as politically motivated. But this narrative is weaker than usual. Attacking a respected federal judge and a trafficking victim carries serious reputational risks, even for the most aggressive propagandists. The unsealed documents will also reveal defense strategies from the 2015 case, offering a rare behind-the-scenes look at how Epstein's lawyers, some of whom moved in Trump-esque social circles, assessed the allegations. Their internal fears, calculations, and concerns about Mar-a-Lago will be laid bare for the world to see. Meanwhile, the U.S. Marshal Service is now responsible for safeguarding these documents before their release. Cybersecurity threats are expected to be high, with potential hacking attempts from various actors. The court clerk's office is preparing a controlled release through secure media channels to prevent server crashes and information chaos. In the long run, this ruling cements the connection between Epstein and Trump in the official legal record. No future historian, biographer, or investigator will be able to discuss one without referencing the other. That is the true power of this decision. It permanently alters the historical narrative. As the clock ticks down to the unsealing, Trump's campaign remains eerily silent. There is no statement that can adequately counter what is about to emerge. No spin that can erase sworn testimony. No tweet that can make this go away. Right now, somewhere in a courthouse, printers are preparing thousands of pages of documents. Journalists are typing furiously, ready to break stories the moment the files go live. And a former president sits in a courtroom, fully aware that when he steps outside, the world will be waiting with questions he may never be able to answer. A pivotal piece of a dark decades-long puzzle is about to be placed on the table. And once it is, nothing for Trump, for Mar-a-Lago, or for American politics will ever be quite the same. The pressure has just been raised to a level we have never seen before.